My name is Billy Boylston, and I'm the Vice President of Governmental Affairs for the Carolinas Credit Union League. Here with me today is Daniel Harms, Chief Retail and Technology Officer for South Carolina State Credit Union, and an attorney with Nexsen Pruet, Kyle Brannon. We're here today to share some exciting news about House Bill 3729. This bill addressed overcharging of storage fees from tow truck industry. What we were seeing over the past few years from our credit unions was a problem with bad actors in this industry who are storing vehicles for months at a time, really for the purpose of increasing their fees for credit unions. When a couple of our credit unions came to us with this problem a few years ago, we at the league started looking into it and met with attorneys like Kyle Brannon, who works with a lot of our credit unions throughout the state on this issue to really see what the problem was of why certain actors in the tow truck industry were sending us higher bills than others. And what we found was that the South Carolina statute was very gray, very murky on exactly what the notification protocol was in South Carolina. So as we started digging into it, we really found that the law was murky and it needed clarification. So that kind of got us to where we are now. We were reaching out to credit unions throughout the state, and one of the credit unions we were talking with was South Carolina State Credit Union, and of course Daniel Harms is here with them. And I'm just going to turn it over to Daniel just to talk a little bit about, what were you seeing at your credit union on this exact problem?
Yeah, well, Billy, this has been a big issue for our credit union and ultimately our members. Over the last several years, what we had seen is from time to time, we'd have a member that we financed a vehicle for, and that vehicle would be towed. The member would not notify us as the lien holder, and the tow truck company under the previous statute had no incentive in some cases to notify the lien holder. And after some time, and sometime an excessive amount of time, we would be notified as the lien holder. And I brought a couple of examples with me today just to kind of illustrate the problem that we had before the recent statute was passed. So I have here a bill that we received for a vehicle that was towed. This is one of our members' vehicles that we financed. The tow truck company towed this vehicle in February of 2022. It wasn't until May 25th that State Credit Union was notified, and that was after 93 days had passed. And when we got this bill, the total amount was $4,135. But of that $4,135, only $415 of that was the towing charge itself. The other $3,730 was storage charges. And this creates a big issue for the credit union, one, because they have to pay that money in order for the tow truck company to release it. But ultimately, this is a member issue because those costs get passed on to our members. And that's why this new legislation, which sets reasonable limits on what storage fees tow truck companies can charge, is such a big win for credit unions and its members.
And I appreciate that. And you hit the nail on the head. Current statute, the confusion of it, that diverted resources that otherwise would have gone to serving your members.
Right.
You're dealing with that bill. Instead of sitting with somebody and trying to figure out how to give them that car loan, you're sitting in the back office dealing with, these bad actors in the tow industry.
Right.
And that's, hurting your membership. So, I know you're experiencing that at your credit union, and that story is the same thing we were hearing all throughout the state. So while this is, just one example, this is just something we saw happening everywhere. And in talking, with different credit unions, again, we're digging through the issue, and of course, it was very legal, which gets us to Kyle's with us today. Kyle works with various credit unions throughout the state and was really instrumental in actually drafting the legislation and really helping us get to the crux of, let's clarify what the notification standards are, how many days it takes. Kyle, do you want to talk just a little bit about, how we got here and really what this bill does?
Yeah, sure, Billy. So, as you mentioned, Nexsen Pruet represents several credit unions in South Carolina, and this was a recurring issue that we saw for pretty much every one of our clients, where before notice was ever given, the tow truck company or, mechanic, body shop had a vehicle for months, and the charges were probably less than $1,000, well less than $1,000 for a tow, but the storage was $4,000, $5,000, $6,000. And if they weren't willing to negotiate, the credit union has a little choice but to either retain counsel to dispute that and file an action to try to recover the vehicle, or possibly pay it, or do the best you can with negotiation. So what we saw was that Section 291510, which is really the heart of the South Carolina Code that deals with this, was vague. It simply said that storage before notice was sent can be charged, and that these entities have to send notice by certified mail within 5 days of learning the owner and lien holder's identities. Well, we think that that identification should have been happening pretty quick, and it certainly should not be taking months. There was an indication in the statute, and we'd actually had some success with several magistrate judges with capping storage at 5 or 10 days, but to get there, you had to litigate. You had to get all the way through that, which of course is not an efficient way to try to, get a vehicle back. And legal fees tend to add up when you go all the way to the point of arguing with the judge. So for this bill, our goal, as you mentioned, Billy, was to have an express cap of some kind on pre-notice storage fees. Not trying to get into the tow charge or the repair charge, but storage. And it's only fair that there be some kind of cap before you even know they have it. So what House Bill 3729, which, as you mentioned, was signed by the governor last month and now ratified, says is that 7 business days is the maximum pre-notice storage that can be charged. Before the letter is sent, 7 days is all they can get. Typically, we see between $25 and $35 a day for storage. So what we now have, or what I hope we have, and I think we have, is certainty. When you're negotiating with one of these entities, whether it's through your counsel or directly, you can now point to a statute that is clear and says 7 days is all you can charge. That's what we'll pay you, presumably. Every situation is different, but you now can point to something clear as opposed to something that was extremely vague.
No, and I appreciate that. And just to recap, so what this bill states, the biggest changes from the past statute to this statute are, what this bill does is caps the number of days a storage facility can charge from date of tow. So once a car is towed, they can only charge for 7 business days before certified registered mail is sent to the credit union or lien holder in other instances. Once that certified notification has been sent, they can begin charges again. So I want to make that clear. So they have up to 7 days to find the lien holder, track him down. If Billy's car gets towed, Daniel has 7 days to track me down. He sends notification to the credit union, but once the credit union's been notified, those charges can begin to accrue again. What Kyle was saying, the problem was the notification piece of this. So what this bill did was created that certainty of you can only charge for 7 days until certified mail has been sent. So in Daniel's instance, when he got that bill for $4,000, but only $400 of it was for storage fees, next time he gets that bill, he's only going to be liable, or that credit union is only going to be liable for 7 business days. Kyle mentioned it is law now. So moving forward, if you start to begin to receive some of these bills, you can contact us here at the league. We're going to be sending out more communications on this issue. But if you begin to receive bills moving forward, you can definitely cite that statute, and we're going to be again sending out more information in written form for you and your compliance team to use moving forward on this issue. But I definitely appreciate everything that Daniel and Kyle have done to help us. And here at the league, advocacy is a top priority with us. The only reason that we knew about this is our credit union shared it with us. Sometimes you don't know what you don't know until somebody shares some information with you. And this is an instance of a credit union coming to us with the issue, and the league having the resources and the time to really research it and finally come up with a pretty good outcome. This time we came out ahead. We can't always win every single battle, but we're going to try. But I definitely appreciate the support of Daniel and his credit union and the legal expertise of Kyle here at Nexsen Pruet. And if you have any questions, please feel free to email me or Risk Compliance here at the league. And with that, have a good day.